Assalamualaikum warahmatullahi wabarakatuh. I am Ainur Izzati binti Shamsuddin. I was born and live in Kuala Krai, Kelantan. My secondary school was at Mahat Ramania Kuala Krai, and then I continued my studies in the foundation in law at Dengkil, and currently I pursue my degree in law at UNIZA. My aspiration to study law is to learn and gain legal knowledge, also to become a great lawyer who can defend others whose rights were infringed by another person. So nowadays, coronavirus disease, which also known as COVID-19, has become a hot issue to be discussed. There are many questions regarding the contract that arise because of this. I expect that all of you have known about the movement control orders which were issued by the government of Malaysia since March 2020 until recently January 2021 to deal with COVID-19. So today I will share with you one of the questions asked by one of my clients that wants to seek my advice regarding the matters of the contract that has been breached because of the movement control order. Her question at that time is whether the MCO could cause a breach of contract. For me, generally, MCO could not cause a breach of contract, as according to Section 7 of COVID Act 2020 stated, the inability of any party or parties to perform any contractual obligation arising from any of the categories of contracts specified in the schedule to this part due to the measure prescribed, made or taken under the Prevention and Control of Infectious Disease Act 1988. To control or prevent the spread of COVID-19 shall not give rise to the other party or parties exercising his or their rights under the contract. Based on this section, if the innocent party that entered the contract is unable to perform their obligations, he or she will not be entitled to exercise their rights under the contract. So the parties may have postponed or rescinded the contract, but it does not cause a breach of contract by the parties since the parties could not foresee and control the COVID-19 pandemic. In addition, the contract that became frustrated because of MCO could not amount to breach of contract. Frustrated here means that the contracts become legally or physically impossible to perform by an event. According to Lee Ching-win and Chuang Yi-xiong case, a Hong Kong court dismissed a tenant's claim that a tenancy agreement was frustrated because the premises were affected by the Department of Health isolation order due to the SARS outbreak, which meant that it could not be inhabited for 10 days. The court held that a 10-day period was insignificant in view of the lease 2 years duration, and that was SARS was arguably an unforeseeable event. It did not significantly change the nature, the outstanding contractual rights or obligation of the parties in the case. Nonetheless, that is not to indicate that a pandemic or events associated with it cannot amount to frustration. No doubt they can, as long as they render performance impossible or illegal or radically different. Based on this, for the COVID-19 pandemic, the agreement that entered may be frustrated because the spread of COVID-19 is unforeseeable. Also, as the agreement becomes frustrated, it is impossible for the party to perform. Therefore, the other party cannot claim damages under Section 74 and 75 of the Contracts Act 1950 due to there is no breach of the contract. Damages can only be claimed if there is a breach of duty by one of the party, but as there is no breach by another party, thus damages cannot be claimed. However, Section 66 of the Contracts Act 1950 and Section 15 of the Civil Act can be raised by the parties in order to restore and recover the money. So that's all from me. If you have any question regarding this matter or need further explanation, you can come to my firm anytime. but you need to make an appointment first. Thank you.